Good afternoon and welcome to our third webinar for third level colleges. Today's webinar is on academic appeals. Some of you will have attended our previous webinars, but for those of you who haven't, my name is Ian O'Herlihy. I'm head of the education unit in Mason Hayes and Curran. I'd like to introduce my colleagues on today's webinar, my partner Paul Rochford and Barrister Joe Jeffers. Now, Joe is an expert in judicial review, and he's worked with us in advising and sometimes representing third level colleges who have challenges of one kind or another in relation to academic appeals. So academic appeals, why have we decided to have a webinar? Well, firstly and mainly it's because just in talking about, our work on behalf of third level colleges, we have realized that there are some, if you like, recurring issues in academic appeals. And there are some problems that we feel third level colleges could avoid. And we don't like to see, if you like, problems occurring which could be avoided. So, in relation to the issues that we're going to talk about today, we have put a little kind of a catchy blurb in our invitation, and we've set out a number of issues that we're going to address, along with some other issues that we haven't mentioned over the next 30 or 40 minutes. And we've decided to kind of approach this by plotting, if you like, the course of an academic appeal as it runs in a college from beginning to end, and to look at the sequence of events and some of the, if you like, trips and falls that colleges have experienced in the process, and maybe see, can we highlight some advice around how to avoid those. Now, I suppose one little bit of encouraging news just on a general level, and that is that both the Irish courts and the international courts have said on a number of occasions in relation to academic appeals over the years that they will never attempt to substitute their judgment in relation to, for example, a student's competence for the judgment of the college, not least because they would have no competence to do that. But having said that, the courts do at times intervene in academic appeals. And we're going to be talking about the kind of the situations where they will and they won't intervene, with a view to trying to assist each of your colleges to get a sense of, some of the, as I said, some of the pitfalls that sometimes can arise. So back to the sequence that I spoke to, the sequence of an academic appeal. And we've divided it up into kind of stages, if you like, just for our own benefit. Stage one is really the issue of the entitlement to an academic appeal. And I suppose I'm going to put a question to Paul, a very basic question. Why should a college, and I know this is in your procedures and everything, but just why should a college give a student a right to an academic appeal? And I suppose the second question that I'll come back to Paul with in a minute is around the appeal procedures in your college itself. So why should a college give an academic appeal at all, Paul?
Thanks, Ian, and good afternoon, everybody. Well, I suppose the very simple answer to that question is that make mistakes and systems make mistakes. As you have said there about the views of the courts in terms of, interfering in the actual substantive decision about a student's competence or progress in a particular course of study, and as we'll explore through the course of this discussion, it is the procedures and the procedural aspects of how a decision is made that come to the fore here. And people can make mistakes in that. So it would seem reasonable and fair that in that context you would afford an individual the opportunity to have a decision reviewed where they feel that the wrong decision has been made or some error has been made in that. And that's heightened, I suppose, by the fact that it always was to some extent, or perhaps more now. Third level education is a higher stakes endeavor, perhaps than it has ever been, and the impact of a wrong decision or a wrong outcome on an individual's future life and career is quite significant. So for all of those reasons, it would seem to be a reasonable, fair thing to do. But it does tie back to the procedure and the procedural aspects of it, to pick up on the second part of your question. And we have found, I suppose, that a lot of the webinars we've been giving in the last few months have had a recurring theme that we keep coming back to. And the theme of today's webinar will be procedures, procedures, procedures. And I think the three of us would often have had clients come to us and say, we have this application that's been brought, or somebody has raised this issue. And I think the first two questions we would ask them are, well, what is your procedure, and send us a copy of it, and right, tell us what you did. And we look at the two of them, and equally the students and the student representatives will do the same. So I think in terms of looking at that procedure, and the things that are important in that procedure are the things that we will talk about through the course of this webinar. So for example, some of the main points you might want to consider when looking at your own procedures. What is allowed to be appealed? So is it a review of the procedure of how the decision was made? Are you allowed to review or appeal anything else? What are the grounds on which an appeal may be taken? What are the basis? And are they defined, or are they left a little bit more open? We're going to talk about the nature or form of the appeal. So does an appeal warrant an oral hearing, or can it be done on the basis of the record, the documents that relate to the decision that was made? A question arises as to who should properly hear the appeal, and that should be set out in the procedure. But I know you and I, Ian, had a case within the last couple of years where there was some question mark about that, and perhaps people had taken preliminary decisions in relation to a query raised by a student, and that complicated the process then, and we had to kind of unravel it a little bit and kind of do a bit of repair to the process to try and make it stand up to scrutiny. And then once you get through that preliminary part and you get to actually the appeal itself, an important aspect of that we're going to discuss is what remedies are available to the college to afford to a student where they are successful in their appeal. And whatever the decision is, whether it's to grant the appeal or not allow the appeal, what are the obligations on a college in terms of the reasons that need to be given for that decision, and how extensive do those reasons need to be, and what do they need to set out? And those are kind of the pillars or the kind of main points in relation to a procedure that you might want to consider or concern yourself with, whether you're, most people on this will not be drafting one from new, but if you're doing a review or you're kind of want to go back and have a look at it, those are the main points you want to concern yourself.
Thanks, Paul. And I think that those kind of general comments will be helpful to the people listening. One of the things that I think you and I have been talking about is that, we remember we were talking to the legal advisor to a student who said that when he gets a kind of a case like this, he just looks at the college's procedures in one hand, and he looks at exactly what happened in the other, and he tries to see any differences between the two. And that's something that we'll come back to, and Joe will be talking about more in a moment, but something we'll come back to, because it's something that colleges, I think, need to keep in their head. That is what, legal representatives of students will do. Joe, can I come to you? I suppose let me ask you a sort of a general question. What should an academic appeal in a third level college look like?
Okay, well, I suppose the first point to bear in mind is an academic appeal is no different from any other type of appeal. And fundamentally, it must be fair. And by fair, I mean there must be a fair process. Or you often hear people saying it must adhere to the rules of natural and constitutional justice, or adhere to fair procedures. And I suppose that's easy to state, but difficult to apply, because the courts have repeatedly said, well, look, the rules of fair procedures are elastic. So they differ depending on the nature of the decision at issue. So someone who comes before the criminal courts facing criminal prosecution is entitled to a very high, if not the highest degree of fair procedures. Whereas someone facing or a decision of lesser importance, where their liberty isn't at stake, perhaps the same degree of fair procedures, such as a right to cross-examine and so on, does not need to be adhered to. So it's very difficult to identify what rules have to be in place because they really are fact dependent. Now, that's in the general. Specifically in relation to academic appeals, you might ask, well, what are the basic rules? What do we, and touching on the point that Paul made, what must go into and be provided for in the underlying rules or statutes? Well, the first one is an obvious point, that the rules must be clearly set out. They must be intelligible and they must be available to students and the public at large if necessary. So if I'm a student and I want to appeal any decision, academic decision made against me, I must be able to access the rules pursuant to which my appeal will be decided. And that's usually addressed by them being made available on request or on the web page of the third level institution. But I can't stress enough how important it is to get those rules right, because it's the rules that give the appeal committee or panel or appeal person, whoever's hearing the appeal, it's those rules that give them their jurisdiction. They give them their power, and they also limit their powers. So it's crucially important to get the rules right in the first instance. Once you get them right and once you publish them, it's really crucial that when an appeal comes into being, that the decision maker on the appeal then sticks to those rules. Because as you said, Ian, solicitors, lawyers will come after the event when someone is disappointed by the result, look at the rules, look at what happened, and try to pick holes in what happened by reference to the rules. So simple point is that the rules need to be clear, they need to be fair, and once they're then published, the appeal needs to be conducted in accordance with the rules.
Yeah, thanks for that, Joe. And that I think is I suppose, one of our basic messages. But let me ask you, I suppose, a question arising from that. I mean, we said a number of times in the last couple of minutes the importance of sticking as closely as you can to your rules and procedures. But is there ever a circumstance where there is a justification in, for want of a better phrase, tweaking the rules or departing a little from the rules? I mean, suppose you have a situation, and you and I have had this, Joe, in a number of challenges, where somebody says that the person hearing the appeal, maybe knows the student, or knows or is very best friends with, or is with the decision maker, the original decision maker, which is being appealed. Is there ever a circumstance where there's a justification in, if you like, departing a little from the procedures?
The simple answer and the short answer is no, because it comes back to the point that the rules are what give the committee its powers. As soon as the committee, and I'm using the word committee, but it may be a single person hearing the appeal, or it may be a panel of people, but as soon as they depart from the letter of the rules, they're in very dangerous waters, because they leave themselves open to a charge that they have exceeded their jurisdiction. So the starting point is the committee get their jurisdiction and their powers from the rules. They're empowered to do what the rules empower them to do and no more. So the simple and the easiest thing to do is to stick within the rules. Now, the point you make is a good one, because it means, and as often happens, a situation arises which creates a difficulty. So somebody brings an appeal panel is appointed to hear the appeal, and the person bringing the appeal says, I don't want X on the appeal panel because they're in the same department as the initial decision maker, and that offends the rule against bias. It comes back to the point that Paul was making. There should be, ideally, flexibility in the rules to allow you, in that instance, to substitute out, if the complaint is well-founded, or the concern is well-founded, to substitute out decision maker A for a substitute. But so I suppose to answer your question, that flexibility should ideally be provided for in the rules. But it also brings into focus another point, which is what I started with was that that the process must be fair. And one of the crucial features of fairness is that the decision maker is independent or impartial from the first instance decision maker. So again, if the concern is well-founded, then by all means, you should look at an alternate, provided that is provided for in the rules.
Thanks to that, Joe. That I think is very clear. Paul, I'm going to come back to you for a minute. Over the last couple of years, we've dealt, I suppose, with a couple of academic appeals arising from assessments in what I might describe as practical disciplines. In other words, not purely academic script-based assessments, but rather practical assessments. And what comes to mind would be things like, nursing degrees, teaching degrees, even something like medical or dentistry, that kind of area. A number of these would have what the colleges sometimes call, vivas or face-to-face assessments rather than written assessments. Any guidance that you would give around those, because they can be tricky sometimes.
They can, and I think that the no surprise, as I said, we'll come back again to the procedure. So what is the understanding of and the student in terms of how that practical assessment is going to be conducted, and how the success or failure is going to be assessed, and because in certain instances you will have, on those types of courses, you'll have placements with external parties. So you may have a nursing student or a medical student placed in a hospital for a period as part of their assessment, and they have to successfully complete that placement. You now have a third party involved in that procedure that leads to an assessment that may then be appealed. So if in almost all cases, the basis of the appeal is on how the decision was made, have you as the college satisfied yourself as to how that external party is making that decision?
Sorry, Paul, just you're on mute there. Sorry now.
Sorry, don't know what happened there. So as I was saying, you have to you as the college have to determine how are we assuring ourselves that the external party that we're dealing with in terms of those placements, how are they doing that assessment and what are the procedures they're using? Because those procedures may then be the subject of an appeal. And there was a recent case that went to judicial review before the High Court involving a nursing student who was in that position where she had failed her practical placement in a hospital in her final year of her nursing degree course. She was allowed to repeat it and then failed it again. And then the hospital said, we're not having her back anymore because we have concerns about her practice. Now, that particular judicial review was decided on other grounds outside of the procedure for assessment, but it did open up some very interesting questions about how the High Court would have looked at a judicial review of that decision if the appeal had proceeded on the basis of looking at why she was not allowed to continue her placement, or why she was not allowed to successfully complete her degree. So I think colleges need to be very aware of the fact that there's an extension of their process now where they have a practical placement, and how do they ensure that they're kind of guarding themselves against challenge to that process or to that procedure as part of an overall review of their academic appeal process.
So I think particularly around practical assessments, we've often advised, I think you and I, that you know, there need to be some criteria around those kind of assessments, or otherwise they may be open to question. Joe, I'm going to come back to you again, and I want to talk for a few moments about academic appeal decisions. Can you give any guidance on decisions when the appeal committee, whoever it is, are actually coming to write up their decision, if you like?
Yeah, well, I suppose there's 2 points. There's the conduct of the appeal itself, and then there is the conclusion of the appeal and the decision. And in relation to the conduct of the appeal, again, to re-emphasize the point we have been making, if you get the underlying rules right, then actually the conduct of the appeal ideally should proceed smoothly, because the roadmap is laid out, and so long as the appeal committee stick to that roadmap, then the appeal should be conducted fairly. And again, we'll come back to that word fair and fairness, and most of these will be, most of the points will be sort of self-evident or obvious, but basic rules, and again, these will often be provided for in the underlying rules, is that if you're accepting submissions from one party, the appellant, you should afford a facility to the other party to make replying submissions. That seems like an obvious point. One issue that sometimes arises, and happened in a case recently that you and I were involved in, someone always has to have the last word, and the other side complain that well, they didn't have an opportunity to respond to the last word, and had they would have said A, B, and C. The easiest way to get around that is to set it out in the rules that there will be either one set of submissions from the appellant, one set from the respondent, and it's always safer to give the appellant the last word, and that would be it. And in most academic appeals, I think there's no reason why the appeal can't be determined on the papers. Oftentimes a question arises as well in any decision-making process: is there a need for an oral hearing? And if there is a need for an oral hearing, are the parties entitled to be represented? And suddenly you're into a huge palaver with solicitors and counsel turning up at academic appeals. But it doesn't strike me that would be necessary. An oral hearing usually is only required where there is a dispute of fact to be resolved. So in a disciplinary appeal, where you're trying to decide between he said, she said, in an academic appeal, there's no reason that I can see, absent extraordinary circumstances, that it couldn't be determined on the papers, provided that is what the rules say that would be the norm. And again, to build in that flexibility, the rules might say, in exceptional circumstances, an oral hearing will be considered, or something like that. And thereafter, the appeal committee must conduct the appeal fairly. They're bound to only take relevant matters into consideration and disregard irrelevant matters. And one other thing to watch out for is that you don't fall into the trap of having heard submissions from both sides, that the panel or the appeal person would go off and do their own research, or would accept subsequent submissions after the appeal has concluded, but before the decision is delivered, from one side only, because that obviously infringes the idea that the appeal needs to be conducted fairly, transparently, and that every side should have an opportunity to comment on the other side's case. And that is, if you like, the basic rules for the conduct of an appeal, and then you come to the decision and writing up the decision.
And thanks for that, Joe. And that, I think, is that issue of, a demand for an oral hearing is something that has come up a number of times. And I think the advice you've just given there is, well, first of all, look at see what your procedures say, and we get back to the procedures. But secondly, that there wouldn't normally be a good reason for allowing an oral hearing. So if I come back to then this question of the decision, and I have two issues. One issue I want to raise firstly is around remedies. So we're, as Paul said at the very outset, we're in a situation now, discussing a situation now where, for one reason or another, an appeal is being upheld. Have you any sort of guidance to give around on the issue of what remedy the appeal committee would decide upon?
Yeah, well, again, and maybe I'm repeating myself again, but it really depends on what your procedures say. As I said, the procedures ought to set out what remedies are available to an appeal committee, and the appeal committee should stick to that. Yeah. It may be that the procedures provide that an appeal committee can substitute, and they ought to describe the nature of the appeal. So is it a full appeal, or is it a review type? Are you looking back to see the first instance decision maker fall into or make a serious error? And is that the standard of review that the appeal committee are applying? Or are they, in the case of a script, marking it afresh? But that again comes back to the point of what do the procedures say, and the procedures should spell that out, because if the procedures are silent on that, then you're into, again, dangerous waters. And again, I've often found, and I think we found this as well, Ian, Paul, that when decision makers depart from the letter of the law, or the four corners of the rules, oftentimes it's for good and benevolent motives. They want to do what they believe to be fair and just in the circumstances. But those benevolent motives are then often, you're subsumed in a high court challenge by way of judicial review 6 months later, and you're thinking to yourself, I wish I had just stuck to the rules. So the safer thing to do is to stick to the procedural rules.
And what about another question just around the decisions? You and I, Joe, have dealt with a number of challenges where a college has bbeen attacked, if you like, for not giving a reason for an academic appeal decision. So have you any guidance to give around must reasons be given, and if so, in what detail?
Yeah, so the short answer is yes, reasons must be given. A reasoned decision is a central part of a fair process. But the courts have repeatedly said that the reasons need not be elaborate, they don't need to be extensive, but they must enable the parties and someone coming to the decision, such as a court on a judicial review application, they must enable the parties to understand the reasons why the decision maker arrived at its decision. So examples have often been given. If you take, for example, a criminal prosecution of a summary nature in the district court, a district judge must give reasons for that decision, but the reasons can be very simply stated. I preferred the evidence of witness A over witness B. That is sufficient, provided someone coming to the decision understands the basis for the decision. And I have found that you sometimes meet decision makers who are very reluctant to give reasons. very reluctant to put pen to paper because they say, look, if I give reasons for my decision, they'll only be picked apart and I'll open myself up to challenge. Well, one way of certainly opening yourself up to challenge is by giving no reasons. So it's fundamental that you give reasons, and rather than it being something to be feared, you should see it as your opportunity to explain the basis upon which you have arrived at your decision. And it is absolutely essential that a court on a review, and we'll come to look at judicial review in a moment, but if they're going to look and say, well, look, was this process fair and fairly conducted? They have to look at the reasons for the decision as part of that. So yes, you have to give reasons, but they don't need to be elaborate or extensive.
Thanks for that, Joe. And I suppose a last question for you, Joe. Usually when a student or a student's legal advisors are seeking to challenge an academic appeal decision in the courts, they do so by way of judicial review. Can you maybe give us some general comments on what is judicial review and what should a college expect it will involve?
Sure. Without, I suppose, going into too much of the historical development of judicial review, as more and more decisions are made by what are known as administrative or quasi-judicial tribunals, the courts realized that it was appropriate that they exercise some supervision or supervisory jurisdiction over that process. So classically, ministers and departments make decisions. The Workplace Relations Commission on Board Planola, all of these bodies make quasi-judicial decisions that affect people's rights. And the courts recognize that they are specialist bodies that have been empowered often by statute or by legislation to make these decisions. And the court will respect the fact that the Oireachtas has bestowed on these bodies the power to make those decisions. But the court will supervise that process to ensure it's fair. So all decisions of a public character, which are made pursuant to public powers, including, for the most part, decisions such as academic appeals made by publicly funded third-level institutions, will be amenable to judicial review. And classically, people say, well, look, what judicial review is about is it's about the process. It's not about the decision itself, whether the decision is right or wrong. It's about the manner in which the decision is reached. And that is correct. And that goes to the point that you made at the outset, Ian, that this High Court, Court of Appeal and Supreme Court, respect the fact that academic institutions, to take this example, are the experts in their field, and that they should be afforded deference in relation to the final decision. So oftentimes you will see a court saying, look, I may not agree with the decision you reached, but you reached it in a fair manner. So there's no reason for the court to interfere. So, and that's a key point. The courts can't sort of usurp the function of the decision maker, but they still will look at the process. And in doing so, I suppose it's important to bear in mind the only circumstances in which they will interfere with the merits of the decision, but the only circumstances in which they should interfere with the merits of the decision, is if it reaches the threshold of unreasonableness. There's various formulations for this, but the courts have said if the decision flies in the face of common sense and reason, fundamental reason and common sense.
Irrationality,
or if the decision maker has lost his senses or lost his mind, essentially. Yeah, but short of that, the courts shouldn't interfere with the merits of the decision, and they should confine themselves to a review of the process. So, and that touches on all of the points that we've made already. Was the decision maker independent, or is there apparent bias here? Did the decision maker exceed their powers? So that's the really important point. Did they do something that they weren't empowered by the rules to do? Did the decision maker take irrelevant matters into account? Was there some fundamental unfairness? So, for example, after hearing the appeal, after hearing submissions from appellant and respondent, did they go off and do their own research and come to a view that way? Or did they accept further submissions from one party, not the other party? And finally, is the decision properly reasoned? And those are the headline grounds and the usual grounds for judicial review. So if the High Court is on a judicial review application is satisfied that the decision maker fell into error or exceeded its jurisdiction, then usually what will happen is the High Court will grant what's known as an order of certiorari, which just means they will quash the decision. And the final point is, consistent with that whole structure and scheme, they don't then make their own decision. The usual course is to remit it back to the decision maker or a different decision maker for a new decision to be made that is in accordance with law and
rules,
the rules of fair procedures.
Sure. Okay, Joe. That thanks for that, and I think that's a really good summary of the sort of application of judicial review in something like an academic appeal. So we're coming towards the end of the webinar. I hope you found it helpful and relevant. I think there's a few recurring themes that we've gone over and over again. Stick to your procedure and maybe keep in mind the image of the student's advisor looking at the procedures on one hand and what actually happened in the other, and seeing is there a departure from the procedure. So just keep that in mind, and it should keep you on the right track. Obviously, there's a basic requirement to give a student a fair procedure, and as Joe has said, to give a student a reasoned decision. So they are basically the sort of fundamental principles. And if just to say, I mean, if we in Mason, Hayes and Curran can assist your college either with a review of your procedures, if you think that's necessary, or with some other things we do are for example, give some training to people hearing academic appeals, if you feel that would help or support your personnel who hear academic appeals, or indeed in dealing with a challenge, a legal challenge, obviously around an academic appeal, we would be delighted to do so. We are intending to run other webinars for you for third level colleges. The feedback we've got for those of you who've given us feedback has been fantastic, and a big thank you for that. But please let us know if there are issues or topics which you would like us to cover and which we haven't covered already, because to be plain about it, we want to support you on the issues that are relevant, that you think are relevant. So please let us know of any of those topics. Other than that, from myself, Paul and Joe, thank you for joining us today, and good luck.